Hi guys, this is Aryan Dwivedi, one of the admins of Lighting Dream. In this Lighting Dream explained part, we are going to discuss two issues. One is the caste census and the second is the Patent Amendment Rule 2021. So let's first start with the caste census. So this is a very prominent issue which has been in the news between the political party from the last 6 months. The majority of the opinion, including that of the opposition and that of even the partners of the present central government, that is the NDA, they are demanding for the caste census. The major concern has been raised by the Bihar Chief Minister Nitish Kumar. They have met with the Home Minister, with the Prime Minister, and they want a caste-based census because of their different issues with it, that having a caste census, it is a political game, it is a economic game. It will be easier for them to think about the different welfare scheme and to provide reservation. This all issues we will be discussing in this session. So now why caste census has again gained a momentum because of the recently the union government, in a response to the writ petition filed by the state of Maharashtra, it has filed an affidavit in the Supreme Court in which it has told that the caste census of the backward classes, that is other backward classes, is administratively difficult and cumbersome. So according to them, that apart from SC ST caste census that is done every 10 years, this, including the other castes like OBCs and the backward classes, it's not possible administratively. It is not feasible. So this government response is in response to the writ petition filed by the Maharashtra government to gather the data on the backward classes, which while conducting the census 2021. Now, what are the stand that are taken by the government against this caste census? First of all, according to the government, it is an unusable data. So the center has reasoned that even when the caste census was done before the independence and the pre-independence period, that data suffered in respect of the accuracy. Okay, the accuracy of that data was not feasible, and the central government said that the caste data enumerated in the socio-economic caste census even of 2011 is unusable for official purpose as they are having the different technical flaws. Second point that was raised by the central government in the Supreme Court against the caste census was that it is not an idle pool tool. According to them, the many people may not register themselves in the census just because of hiding their caste, which means it will be compromising the integrity, the basic integrity of the caste census. So the government has said that the caste-wise enumeration will give up a matter of policy from 1951, because it was given up as a matter of policy in 1951 because the people are not willing to bring forward their caste, because they think that this will be taking another aspect. It will not having a positive aspect. Bringing caste in the census will have a negative aspect. And the third is that administratively it is difficult. The government has told that it is too late now to enumerate caste into the census 2021, because the planning and the preparation of this census has already started 4 years before, and now it's almost done for the census 2021. So also, as you know that the census 2021 has been delayed because of the corona pandemic and all, but it has to be done by the end of this year. So the government stand is that 4 years before we have started the preparation for this census, and it is not feasible and possible at this point of time to enumerate caste into the census. So these are the government stand that the government has taken in the Supreme Court against the writ petition filed by the state of Maharashtra. Now, why the opposition government or the various parts of even the present government of the NDA, like the Bihar Chief Minister Nitish Kumar and various parties of Maharashtra and Uttar Pradesh, they want this socio-economic caste census. According to the expert, it will be useful to establish statistical justification for preserving caste-based affirmative program, and according to the caste-based data, the welfare scheme will be given. So they, according to them and even by the expert, it has been told that various welfare schemes do not reach the needy people because we don't have a caste data. So if we have the possible data of how many OBCs are there, creamy layer, non-creamy layer, then every state government and the central government can make welfare scheme taking into consideration this caste or the OBCs or the creamy layer. Second, the argument by the expert and by the various government is that it will be legally imperative, because just example we can take the example of the Maratha reservation. So the Supreme Court has struck down the Maratha reservation just because there was no quantifiable data to support the reservation. So if we are having a caste-based census, we are having the data about the OBC, the creamy layer, non-creamy layer, then we will be having in a better position to even we can be breaking the 50% reservation cap. This has been one of the issues that has been raised by the various experts, that it might be possible that the 50% reservation cap has to be also removed if we have the caste census. So these are the arguments in the favor of the socio-economic caste census. The last socio-economic caste census in the last 2011 census, caste data was enumerated in the socio-economic caste census, that is SECC, in 2011, but it was not released by the by then government and neither by this government, because of the they told that there is some flaw in the data. Now the census is what census started in 1881. It was started by British Viceroy Lord Mayo, which is used by the government, the policymaker, academics to capture the population of India for the welfare scheme, for the resources, for the delimitation purpose, for various mapping of the various for the various purpose. And the Census Act, we have a Census Act which came into force in 1948, and the first census of the independent India, that is the census of 1951, was conducted in accordance with this act. After which, after every 10 years, census is conducted. The last census was conducted in 2011, and now we have 2021. The census is yet to be completed. Now, what is SECC? That is the socio-economic caste census. This was first time done in 1931. After which it was stopped because of the flaws which was coming in it. Because of which, in the after our independence, not a single socio-economic caste census has been done. Now, this socio-economic caste census was to ask the people of the rural and urban India about their economic status, so that the central and state government can come with a range of a indicator about the deprivation, permutations and combinations of each authority of who is a poor or who is a deprived poor. Now, this SECC, it also mean to ask every person their specific caste name to allow the government to re-evaluate that which caste group are economically worse off and which were better off or which are better off. So if the government has the data for the caste census, then they would be knowing that acha, OBC are having the creamy layer are having, they are in a better economic position, so we should not provide the reservation to them, or the other caste are having not a good economic condition, or whatever criteria they are taking into consideration, then we should be giving them the reservation. So this will be helping the government. However, the SECC has not been conducted after the independence. Only the castes were enumerated in the 2011, but it was not used, and not the data was not even released by then government and not the present government. So that is the SECC. Now we have to understand what is the difference between census and SECC. The census, it provides the portrait of the Indian population, the whole Indian population. Because if you have participated in a census, you must have seen that they ask that what is your name, what is your age, how many people are there in your house, unka naam kya hai, what is their name, age, what they are doing, how many that grandfather, daughter, and this all thing they ask. That is the maximum they are doing to know that what is the current population of India. Okay, but the SECC, that is a socio-economic caste census, is to identify the beneficiary of the welfare scheme that are provided by the central and the state government. In the census, under the census, which is come under the Census Act of 1948, all the data are considered confidential. But when it is a SECC, there is a website where all the personal information, that who belong to which caste, which religion, all will be open, and it will be used by the government not only, but even to the other public. It is told that it will be used by the government for the benefits or the welfare scheme, but it will be an open data. Then every person will, as it's already taken stand, the government has taken the stand that many people may not register themselves in the census in the event of hiding their caste, which will be compromising the basic integrity of the census. So caste is a confidential data, whereas census is a confidential data, whereas SECC is an open use by the government department, which it comes on the website. Now, what should be the way forward? The government can go for an parliamentary study which can be done at the state and the district level to establish all the sects and sub caste which are present in the population, or they can be used various other techniques, other NGOs, with the help of the NGOs or other surveys they can be do for this purpose, for the caste of the population present in the country. But going for an SCEC is not feasible at this point of time, as had been held by the central government. So this is all about the caste census. It is a very important and a very burning topic from the last 6 months to 1 year. So it is a very high probability of coming in your Clat examination, that you should be knowing that what is census, what is SECC, why there is a demand for a caste based census, what are the stand taken by the government, what is census, what is SECC, what is the difference between them, what are the benefits of SECC, what are the against disadvantages of SECC, and whether it should be conducted or not. So you should have a clear idea about it. The next issue that we are going to discuss is the Patent Amendment Rule 2021. So recently the government has brought an amendment to the patent rule. Let's have a discussion on this. So recently the Union government has introduced Patent Amendment Rule 2021. The sole purpose of this amendment is to reduce the fee for patent filing and prosecution for educational institution by 80%. So whatever new development are being made by the educational institution, whichever educational institution, it is not, it should be recognized by a government. The new rule state that it might be any educational institution, whatever new research or development they are doing, they should be in a position to register their patent, and and as a result of which the fees has been reduced by 80%. So patent is just a form of the preservation of the intellectual property right, means the owner of that particular, whoever has invented any invention that he has done, any product in general or whatever solution he has brought, he should be having the exclusive right for that particular invention. So the patent should be a very unique thing that should be made by the person who is making it, and then he will be granted the patent. So we have trademark and patent. Trademark and patent are two different things. Patent is a form of preservation of the intellectual property right, in which the invention of a person. In trademark, for your business, for your school, for example, it might be two school are having the same name, for example, Brilliant Public School, Brilliant Public School. That is the infringement of trademark. That is not an invention. Patent is granted when you make an invention. It can be for anything, whether it is for industrial purpose, fruit, food, book, or anything that you invented as a solution in the world. So for giving the patent, for getting a patentability, with the criteria are that it should be a novel thing. It must involve an inventive step. There should be technical advancement, and it should be capable of industrial application. If your invention is having this all three criteria, then you will be giving the exclusive right over that particular invention. So now understand the term of the payment, that for which year, for what duration does you get your patent exclusive right. So the term of every patent in India is 20 years from the date of filing the patent application. Okay, for that we have the Patent Act 1970. We had the Patent Act of 1970, which came into force in 1972, and then in the year 1911 we had the, till 1911 we have the Indian Patent and Design Act. In 1970 the Patent Act was brought in the year 1972 into force, and replaced the Indian Patent and Design Act of 1911. Then it was amended by the Patent Amendment Act 2005, wherein product patent was extended to all field of technology, whether it was food, drug, chemical, microorganism, book, or any invention that you are making. After the amendment, the provision related to exclusive marketing rights, this was repealed, and a provision for enabling grant of compulsory license was introduced. So a compulsory license will be issued to all these people who make a extraordinary invention in any of the field, whether it is of the food, whether it is of the drugs, for the chemicals, microorganism, for any field of technology, as it was changed by amendment of the Patent Act of 1970 by the 2005 Amendment Act. Now, what are the provisions for the Patent Amendment Rule 2021? So, according to the government, the educational institution, they are engaged in various research activity where the professor, student, teacher, they generate new technology. Okay. So, according to the government, this all the research work that are being developed by the government, by the educational institution, they need to be patented for facilitating commercialization of the same. So therefore, in order to regard and encourage greater participation of the educational institution, Okay, they have been the fees of registering for the patent has been reduced by 80% to all educational institutions. Before it was available to recognized educational institutions which are owned by the government, but now it has been made available to every education institution. Whoever is doing any good research, they can file their patent by a fee reduction of 80% has been made for them. So this is a new rule amendment that has been made to the Patent Amendment Act. The original act is of 1970, which came into force in 1972. Then in 2005, some amendments were made, and then we have the Amendment Rule of 2021, which the sole purpose is for the educational institution where the patent fee has been reduced, by 80%. So that's all for this Lighting Dim explained part. Thank you.